Chapter 8, the Treaty of Waitangi and Tikanga. 8.1 Introduction. The Treaty of Waitangi is a treaty between the British Crown and most of the Māori chiefs in New Zealand at the time. It was signed in 1840. For context, Māori are the indigenous people of New Zealand. The treaty is not directly part of New Zealand's law. However, it has been recognised by the courts and Parliament as a founding constitutional document of the country, and it does have some legal implications, which we'll look at soon. The treaty is actually quite a short document. It's only made up of a preamble, or an introduction, and 3 small paragraphs known as articles. The first article gives the British Crown sovereignty over New Zealand. The second article allows Māori continued possession of their property. It also gives the Crown the right of preemption, which means if Māori choose to sell their land, they have to offer to sell it to the Crown first. The third article says all Māori and people in New Zealand get the same rights as British subjects. 8.2 Lost in translation. The treaty was written in both English and Māori. Most of the Māori chiefs read and signed the Māori version. Unfortunately, there are a few key words that got lost in translation. For example, the word sovereignty is used in Article 1 of the English text, but in the Māori text, the word kāwanatanga is used, which translates to something more like the word governance rather than sovereignty. What this means is many Māori did not believe they were giving British full sovereignty or ownership or control of New Zealand. Māori thought they were allowing British to govern the country but not have full ownership of it. This is obviously a major issue and one that is still debated frequently in New Zealand today. 8.3 The treaty's legal status. In New Zealand, treaties only become law if Parliament turns them into legislation. This hasn't happened with the Treaty of Waitangi, so it's not directly part of New Zealand's law. You can find the treaty in schedules to statutes. So for example, the Treaty of Waitangi Act 1975 includes the treaty in a schedule. However, this is just referencing the treaty for context. Again, the treaty itself is not directly part of the law in New Zealand. However, the treaty is legally relevant in several ways. 8.4 Principles of the treaty. Both court cases and Parliament have said that the principles of the treaty can be legally relevant. What are these principles? Basically, the principles of the treaty are the intent or the spirit of the treaty. The principles are about forgetting about the translation issues and just looking at what the parties who signed the treaty were actually intending when they signed it. The parties intended to work together as partners in good faith in relation to governing New Zealand. The principles therefore focus on the values of partnership, protection, and participation. So how do these principles affect the law? Well, judges can refer to the principles of the treaty to help guide them when making decisions in court, especially decisions that impact Māori. For example, in the broadcasting assets case, it was held that the British Crown had to actively protect Māori treasures, like the Māori language, in order to behave in accordance with the principles of the treaty. Also, some statutes say that the principles of the treaty must be considered by particular entities when they exercise their powers under that statute. For example, this is mentioned in the State-Owned Enterprises Act 1986. 8.5 Tikanga defined. Another important legal principle in New Zealand is called tikanga. Tikanga basically means the customary practices and behaviours of the Māori people. It's the values, standards, principles and norms of the Māori people and what is considered appropriate behaviour in a particular situation. For example, in Māori culture, you shouldn't touch someone's head unless they ask you to. Also in Māori culture, individual people are considered the responsibility of the community. These 2 principles form part of tikanga. Tikanga is considered the first legal system in New Zealand. 8.6 Tikanga in the law today. The Supreme Court made a significant decision in relation to tikanga. The court said that tikanga is and always has been part of the common law in New Zealand. By the way, the common law means case law or judge-made law. However, the way tikanga is included in the common law is not exactly clear, and it's also not clear how it's going to be included in the future. In that recent case, one justice in the Supreme Court said that going forward, tikanga principles might be considered when making decisions in court cases by judges when it's relevant. Tikanga is also part of New Zealand's law because its principles are considered in particular statutes and regulations. Also, sometimes public officials consider tikanga principles when making decisions. Alright, we have now reached the end of the substantive part of this course. Amazing job, good work. In the next chapter, we're going to cover some of my personal practical tips about finding and reading statutes and cases in New Zealand. See you soon.